Hello and welcome to Rights and Recourse, a program that tackles legal issues, bringing you information and analysis. My name is Dumile Matez. Remember, you can also be part of our discussion today by tweeting us at Rights and Recourse or calling our studio line on 011 714 5497 or 5498. Alternatively, email your thoughts about this program and many others to rightsandrecourse@sabc.co.za. From the very outset, the process of political negotiation that resulted in the new constitution, the major political players agreed that the new South African constitution should be a supreme and justiciable constitution and should abandon the Westminster constitutionalism that had informed South Africa's constitutional development up to this point. This agreement made possible a lawful transition from apartheid to democracy. Today on Rights and Recourse, we traverse the road traveled since the adoption of the Constitution 20 years ago. But first, let's have a look at this insert.
The Constitution gave us a country. It wasn't just a document. Once you got independence, then you get a constitution. It really constituted the nation. We got rid of the Bantustans, we got rid of apartheid, we achieved dignity for everybody, we achieved our rights, we achieved a Bill of Rights that's for everybody. It's not for majorities and minorities and blacks and whites, for human beings. So in that sense, the Constitution humanized our people. And we paid enormous attention to the detail. It took 6 years. There's this common idea that somehow the saintly, marvelous Nelson Mandela got together with the wise, pragmatic de Klerk, and they got into a corner and did a deal. It wasn't like that at all. It was a rough process. It took 6 years. There were breakdowns, people were being killed, Chris Hani was assassinated, we had massacres, we had rolling mass action, we had as much going on outside the negotiating chambers as inside, but eventually we got the Constitution. And we made it, we South Africans made it. We looked into each other's eyes and we got a basic foundation, how can we live together as equals? And the Constitution didn't establish a status quo that couldn't be altered. The Constitution established a framework of rights and justice and freedom for us to move towards transformation and change. And the theme of transformation, Tebogo, is written right into the Constitution itself. It speaks about achieving full rights for everybody. It's an idea of a document that moves, as a country moves. And really what we need is, if there are problems, and there's serious problems in this country, use what the Constitution gives us, the freedoms and rights that it gives us, the rights of workers to organize, the rights of people to protest peacefully, the right to vote, the right to speak, the right to challenge, the right to demonstrate. These are all rights we get from the Constitution. Use them to get the changes that we want. Don't denounce the Constitution. There's nothing in the Constitution that prevents major change in this country. On the contrary, we crafted it in such a way as to promote change, to promote transformation. What was vital, though, it had to be on the basis of full equality, non-discrimination, and opening the possibilities of the transformations we want. And that's what we got through our Constitution. It was a very bitter, hard struggle. We fought over every comma and full stop. It wasn't one for me, one for you. But we found the way. We found the way, we found the words, we found the ideas. And that's why our Constitution is so admired in the world. I felt so proud, Tebogo. The other day I'm watching on TV, quite recently, as I think millions of South Africans, the Constitutional Court in action. The President goes through his council to the Constitutional Court. He accepts the supremacy of the Constitution. He accepts that the Constitution rules, that he, in that sense, is subject to the Constitution like all of us are, with powers given to him under the Constitution, with responsibilities imposed upon him under the Constitution. And I'm seeing the debate, the argument, the beautiful building that it's in. I'm seeing people from all backgrounds, EFF and their red outfits sitting in the court, eyes, bigger sources, listening. I felt so proud. We've achieved this something in South Africa that's very, very, very special. And it relates to the Constitution. and to the source, that sense of deep justice that everybody wanted. And that's what I believe we put into the Constitution. If people feel our leadership hasn't risen to the possibilities given by the Constitution, well, that's something for their party, their organization, for the voters, for people outside to deal with. Don't blame the Constitution. Use the Constitution.
Justice Albie Sachs, retired, speaking to SABC producer Debucho Alexander. To discuss today's topic, we are joined in the studio by Professor Shadrach Guto, Director for the Center for African Renaissance Studies at the University of South Africa. Professor, good afternoon and welcome to Rights and Recourse.
Good afternoon to you, although I'm no longer the director, but I'm a professor at the Institute for African Renaissance Studies at the
Thank you for that. Our apologies.
Yeah.
Professor, question number one. We heard what Judge Albie Sachs was saying, reminiscing about the Constitution. The question I want us to get out of the way first, what is the difference between this constitutional democracy that we have and the Westminster system? How different are the two? In other words, why do we say our Constitution is the supreme law of the land?
We say that the Constitution is the supreme law, not just because it is written into the Constitution, but a decision was made in the making of the Constitution to say we want to move away from the old order where Parliament was considered to be supreme, and that is the British model. So Parliament is able to make any law. It can go for administrative review, but that is just a review. But the Constitution, and first of all, Britain doesn't have a constitution to start with. It has custom, conventions. It's one of the few countries with no constitution. So because it evolved as a custom and behavior in Britain, Parliament used to have that power. Now ours is a written constitution where we made a choice that we are going to make the Constitution the highest law in the land, and we want to build constitutionalism rather than just having a constitution. Therefore, we have within our section 1 of the Constitution the founding values of the Constitution, where the supremacy of the Constitution is one of them, not the only one. Then we do have section 2 immediately, declaring the Constitution the supreme law of the land, and any law or any action that goes against the Constitution is null and void. And that is really what we are dealing with in South Africa. It's a different paradigm, whereas the Westminster model, based on the British practice, which many countries adopted when they became independent, because Britain helped to write the independence constitutions, they made Parliament to have more powers. But even there, you do have problems, because is Parliament really supreme in many of the countries with Westminster model? The executive usually dominates even Parliament.
The other question I wanted to ask related to that question is the fact that one of the problems many people foresaw, the drafters of the Constitution foresaw, is that when somebody raises something, or say a judge raises something in a case and say this is not supposed to happen, this is wrong, this is unconstitutional. If Parliament was the supreme, was in the supreme position as the Constitution is, Parliament would just go and create another law, as we saw in apartheid during the apartheid days.
That is true, and that is part of the problem that was being cured by the new Constitution. And the Constitution is very clear that even the laws which are passed by Parliament, which are usually drafted by the executive, taken to Parliament to panel beat and pass, if Parliament passes a law and Parliament is not very clear, Parliament has a responsibility, or members of Parliament, to refer it to the Constitutional Court to certify whether it meets the constitutional principle. So the laws that are made must conform to the Constitution, and that is why you find a lot of laws when they go to Parliament. Some of them, certain provisions are found to be unconstitutional, even those which were made after 1994. So it's very, very important that people understand how to interpret the law, and when you do so, you have to look at the Constitution in its holistically before you insist, but this is in the law. Yes, it may be there, but it may conflict with the provision in the Constitution.
In other words, many people say, do all of us, John citizen, and even members of Parliament understand this very issue that Parliament is the Constitution is supreme?
Supremacy of the Constitution needs to be unpacked and understood by the citizens so that the citizens can own the Constitution. Part of the problem is many do not, even members of Parliament, even ministers, even the president, sometimes even scholars. Many do not know what this means, so they use it as a slogan, but without understanding its implications. And I think that is where we need, even when after elections, there should be really serious capacity building workshop for parliamentarians to be able to understand before they start their work of making law, holding the executive accountable, and so on. Because if they don't understand it properly, then they make a lot of mistakes when they speak, and people who understand the Constitution get really angry to say, you are elected, you are supposed to be representatives under our Constitution, and you don't seem to understand it.
I wanted to ask this question right at the beginning. To what extent is our Constitution influenced by the Freedom Charter?
I think the Freedom Charter, of course, there were demands and also a vision for what the Freedom Charter was drafted in 1950s. And the 21st century is a long period where there are many things which were not in the Freedom Charter, which are in the Constitution, and the constitutionalism requires that we evolve the principles and norms. So yes, the Freedom Charter influenced the negotiations that led to the adoption of the interim constitution in 1993, which we used from 1994 to February 1997. It was the interim constitution. This new constitution is not 20 years old because it was adopted and it became effective in February 1997. But it was guided by some of the core principles that were negotiated earlier. So the Constitution had to conform with those principles, and that is why when it was adopted in 1996, it had to go to the Constitutional Court. The Constitutional Court found that there were certain provisions which did not meet the threshold of the principles, and it was returned to the Constituent Assembly to go and correct those, and then it went back to the Constitutional Court, and the Constitutional Court blessed it. So I think that is important for us to see the steps and the road that was followed.
The other question quickly, Prof, you mentioned the Constituent Assembly. Many people are not aware that the Constitution was drafted by the Constituent Assembly and not by Parliament.
It was one where it was, in terms of its drafting, the Assembly was able to gather public opinion, and more than 1 million people gave their views on various aspects of what they wanted to go into the Constitution. And from there on, it was adopted by all major political parties that were represented. They were helped, of course, by the technical committees and so on. And I think it is important for us to say it was not just adopted, it had to be approved to be a law. It had to be approved in Parliament, but after going through the whole process. But there was heavy level or people's participation in making.
Well, we'll continue our discussion of the Constitution of the Republic of South Africa. That is in its 20th anniversary this year. If you'd like to join us in this discussion, you can call us on 011 714 5497 or 714 5498 or tweet us at Recourse. Stay with us.
News Today takes an in-depth look on news locally, continentally, and globally. We bring the world to your home. We cover all economy news extensively to keep you informed. We are live to break news as and when they happen across the world. We analyze news using experts in all aspects. Make a date with News Today every Monday to Friday from 3 to 5:30 p.m.
Tonight in an SABC exclusive news expose, we show you how firearm proficiency certificates are fraudulently sold for a few thousand rand.
What you did was illegal. Do you at least acknowledge that? What you did is illegal.
I say it could be probably illegal.
Nigeria is Africa's second largest tomato producer.
The chief executive of Enrisco says he started the company with a capital of $75 million.
The problem now is that the market has been created in China.
He says that doing business in the country is becoming more difficult every day.
Well, we're here to celebrate the supreme law of our country, our constitution. And we're at the Constitutional Hill. The Constitutional Court is housed here. And this is an old prison where people who stood against apartheid used to be imprisoned, detained and tortured. But this is a place which has been radically transformed into the Constitutional Court, which is the final arbiter on everyone's action in this country. Parliament, President, Minister, and everyone. This is the back ends and stops here.
Well, there you are, Matthew Posa, former ANC treasurer and also former premier of Mpumalanga, is talking about what touched me was his reference to this is the final arbiter, whatever anybody wants to do.
Yeah, I think the term is using a legal term which we normally use. But to break it down is to say it is the one that decides on the validity of any action which is done according to the laws of the country and the Constitution. So the Constitution is supreme, and that is extremely important. That the supremacy which we talked about earlier is, and the courts become the actual institution that authoritatively interprets the Constitution. And the highest court in the country, the Constitutional Court, makes a final decision on any action or any law. And therefore, it is the final arbiter using the Constitution and the laws of the country. And I think that is important. It is not just the Constitution on paper. Institutions must be there, and that is why part of the principles in the Constitution which are important is really the independence of the judiciary, and people are obliged to obey the court decisions. That is written in the Constitution. That becomes quite important.
During the week, we saw this happening practically, where Justice Mbuyiseni Madlanga was delivering a judgment regarding the police being brought into Parliament to remove members of Parliament. This is the kind of issues the court is there for, to interpret the Constitution.
Very important, but I think there's a larger question there, because before the Constitutional Court decision on the action in Parliament, we had building up among political rhetoric of people saying the judges were not elected. We should be ruled by those who elected us, not those who are not elected. And therefore the courts are beginning to run the country, which was wrong. It was misunderstanding the role of the courts in society. And that's why I'm saying an independent and impartial court is key to making the Constitution stand on its feet. And therefore, from that point of view, the courts are the guardians of the Constitution.
Prof, let's take this call from Lucky from KZN. Lucky, good afternoon and welcome to Rights and Recourse.
Good afternoon, Mr. Matreza, and good afternoon to Professor.
Good afternoon.
Yes, Lucky.
Sorry. Yeah. I just want to ask a few questions. The Constitutional Court and our highest court, when the judges take decisions in the highest court, then next day they say it goes to the Constitutional Court. Do the judges take into account all the facts that the Constitutional Court will take? If so, why don't they decide on a matter such that there will be no need for the Constitutional Court to decide? And then my second question is the Constitutional Court not maybe end up undermining the work of the highest court?
Is that your final question? Thank you very much, Lucky. Lucky asking a fundamental question there, and the one that when a decision, when a high court has taken a decision that has constitutional implications, it is sent to the Constitutional Court for certification. Am I right, Omar?
You are quite right, and I think Lucky was right, but it comes from the fact that there is hierarchy within the judiciary, where you have the magistracy at the bottom, then you do have the high courts, then you have the Supreme Court of Appeal, which used to be the highest court in other legal matters except the Constitution. And then the Constitutional Court was there initially just to deal with interpreting constitutionality of matters. That's why it was called the Constitutional Court. But that has changed, and now the Constitutional Court is the highest court in the land. And the idea of having this hierarchy is that if any mistake is made in interpreting the law and applying it, people have the right to appeal to a higher court. And you can appeal to the higher court, whether from the High Court to the Supreme Court of Appeal, and after the decision is made, the Constitutional Court has to be able to certify it.
The other question he asked, rather strangely, is if a matter is referred to the Constitutional Court, will the judges of the Constitutional Court not undermine the lower court? But as I understand, is the judges do not deal with issues that are with the relevant issues to that court. They deal with the constitutional issue.
No, it is quite true that the High Court deal with every court must apply the Constitution and therefore deals with...
In other words, they don't deal with the merits.
Constitutional matters. And I think that ought to be really understood. The Constitutional Court is not undermining the others. All it is doing is certifying. That is, and there are cases where the Constitutional Court has amended some of the decisions made below, and that is why it is there, so that things are aligned to the Constitution. I don't think that it is undermining. The other judges can make every decision. As we saw in the Oscar Pretorius case, it had to go up to the higher court, and they made this different decision from the judge. It doesn't mean that the judge did not know the law, but the judge interpreted the law in a manner that did not fit the facts as they were. And because of that, the higher court were able to correct that so that it doesn't remain in our books as this is what the law really says and this is how the punishment should be. So there are many examples that one can be able to give in that respect.
The Constitution has a preamble. I would think that, as many have pointed out, that the preamble, we the people, actually places the Constitution slam bang into the ownership of the people of South Africa.
Yes, it is a pledge. The preamble is a pledge. And in interpreting the Constitution, we also need to look at the preamble to see what were the real commitments, the vision of a society we wanted to create. And that is why it talks about, among other things, justice, social justice, and so on, which we don't find necessarily written in the Constitution. But you can interpret with the Constitution within the guide of the preamble, very, very important, with people. So the Constitution is a Constitution made, as I've already indicated earlier. People participated in making it, and South Africans as a whole, the whole population is saying, we adopt this Constitution, and therefore we are all bound by it, and it is ours. It doesn't just belong to lawyers, or to judges, or to Parliament, or to the executive, or to the political party which is ruling, and so on. No. It belongs to South Africans, and it gives the people, therefore, the ability to be able even to use it to challenge certain actions that are happening in the country, using the Constitution to say, the Constitution requires you to do this and you are not doing it. As a citizen, I have a right to be able to challenge what you are doing.
I was saying to somebody in relation to this Freedom Charter, to this We the People preamble, and I was saying now this We the People is a relic of the Freedom Charter.
Yeah, very little, I mean, of We the People is borrowed from the Freedom Charter, but it could have been crafted even if it was not there. So the Constitution was not just about, let us copy what is in the Freedom Charter. The Freedom Charter contributed even to the interim Constitution and the final Constitution, but it is not the framework which was being looked at in order to draft the Constitution. I think that myth that has been created, everything comes from the Freedom Charter, is not true.
We always hear people talk about the Freedom Charter. We always hear people, we want this to happen because it is in the Freedom Charter. I think people should put the Constitution above the Freedom Charter, I think.
Definitely, the Constitution is above everything else. It doesn't matter where the document was, what the thought was, and so on. It is not just, because it is in the Freedom Charter, it must be done. But is it constitutional? And does it adhere to the laws of the country? A lot of laws have been made since 1994, and those laws override the Freedom Charter even before the Constitution comes in. So it is very important. The Freedom Charter is not law. It is a political statement for liberation struggle to give people the spirit of fighting for certain goals and so on.
We'll continue our discussion with the professor. Let's now take a break. And when we return, if you'd like to join us, you can phone us on 011-714-5497 or 5498. Or tweet us at Recourse, or email your thoughts about this program and many other programs to rightandrecourse@sabc.co.za. Stay with us.
SABC News, we report, contextualize and present news and current affairs honestly, fairly and fully. We consider it a duty to provide consistent, relevant, useful and top quality information and analysis. Our mission is to provide credible, accurate and interesting news programming, bringing news into everyone's homes in everyone's languages. Thank you, South Africa, for relying on SABC News for quality news output and for making us your #1 source of information. SABC News, Africa's news leader.
A romantic adventure film starring Ivan Botha and Donnelly Roberts. The story begins in the beautiful vineyards of Paarl in the Western Cape. The adventure takes off when the characters find themselves on the tropical island of Love, Mauritius.
Josephine's work is more interesting and distinguishable. She visits war-stricken zone countries to tell the story of the damage war often leaves behind.
This particular exhibition's case, places that are named after conflict or disaster or war or reconciliation.
And basically what it is it's a collection of the best animated short films from around the world this year. And the idea is to inspire animators and directors with this exciting content. And so that's been offered to us as a cinema, and we're very excited to be screening the animated show of shows here in South Africa.
Join Refulo Mula for that 1-hour weekly dose of arts and entertainment news every Friday at 9 p.m. on Trends.
I think it's a reflection of where we are coming from and what we are busy with at the moment. So it's capturing contemporary history, I think, and I think it's fantastic that it's being done in such a way that it reminds us of our history in terms of the struggle, in terms of the demise of apartheid, in terms of establishing and building the democracy, and it's fantastic that it's being put together in this way.
While we continue our discussion here after the words by Rolf Meyer, one of the men who crafted the negotiation process and the Constitution. Prof, the Constitution really finds its meaning and usefulness in Chapter 2 of the Constitution with the Bill of Rights that guarantees a number of rights.
Chapter 2 is very important. That is the Bill of Rights in the Constitution that really spells out what the rights people have, but also obligations, because every right has an obligation. If I have a right, you have an obligation to be able to respect that right. And people don't understand that. They just think that when you have a right, it is unlimited. That is not correct. We do have within the Constitution, in particular, Section 36 of the Constitution, which deals with the limitations of the rights. That you do have a right, but those rights may be limited in a reasonable manner in a democratic society that we are trying to build. And I think that is what people don't understand, because if I have the right to demonstrate, in demonstrating for whatever, whether it is service delivery, I don't have a right to beat you up with the rubbish and to, I think that becomes important. It is limited. We have freedom of expression, but you cannot use freedom of expression for creating hatred that create violence, and you can't use it to propagate war. So we do have all those limitations. That is important to be able to understand that Section 36 is also part of the Bill of Rights.
Prof, let's hold it there. We have this call from Mr. Mhlongo from KZN. Mr. Mhlongo, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir, and your guest.
Yes, Mr. Mhlongo, what is your point on the Constitution that we are discussing today?
Well, my question is to the Prof. It's regarding the constitutionality of the matter that has referred, it's a political matter that has referred to the Constitution, which basically emanates from the fact that the public protector found that the president has to pay some some money. Can the Constitutional Court endorse that finding from the public protector, or can the Constitutional Court find against the public protector in this case? Thank you.
Thank you very much, Mr. Mhlongo. Mr. Mhlongo raises a very important issue, but the problem is that case is still before the Constitutional Court. Without preempting the case, probably we should say, what is the role of the Chapter 9 institutions?
That is quite clear, and that is what is before the Constitutional Court, to clarify what it means, the remedial actions that are being recommended or are being ordered by the public protector, because she has that right, or that office has the right in the Constitution to be able to make those. And when it was made, the executive arm of government started playing around with the remedial action on saying, no, let us take it to Parliament. Parliament sets another committee, the executive sends another committee, and so on. And those committees are not equal to the office of the public protectors and the powers that are given in the Constitution. So it is not just a political matter. The public protector was not dealing with politics, but trying to do an investigation to find out was public money used, and was this authorized, and found that no, it wasn't, and therefore the owner of the property or the home has an obligation to be able to pay the state back some of that money. That is what the issue is. It is not that the courts are now beginning to decide on political matters. Neither was the public protector really engaging in. And the public protector was using provisions in Chapter 9 on Public Protector's Office. They were using Public Protector Act. She was using Executive Members Ethics Act. It was using the National Key Points Act. So these were law-based, and that is all that the Constitutional Court is going to deal with, not with the politics around.
Let us touch on the other Chapter 9 institutions, the Human Rights Commission, the the Commission for Gender Equality, and others. Well, how strong are they compared to the Public Protector's Office?
Well, I think that when they started operating, of course, it depends on who is really in those offices. The Public Protector is one person appointed once, and therefore when you talk about the office of the public protector, it's very easy to connect it with the person who is the public protector. The others are commissions. The Human Rights Commission, there are commissioners there and a chairperson. The Commission on Gender Equality, there are commissioners and a chairperson. Then you have the commission dealing with the culture, languages, and so on. That also is a commission with a chair and commissioner. So
we'll explore this issue of the Chapter 9 institution, Prof.
Yes.
Let's first take this call from Marlo from the Northern Cape. Marlo, good afternoon and welcome to Rights and Recourse.
Good afternoon. Prof, what's your view on leaders that make statements and say that the judiciary wants to run the country? Is the court not there to interpret the law and give direction accordingly?
I think that question, thank you, Marlo. Marlo, I think the question by Marlo also have it here, where we have seen politicians saying the courts wants to run, the opposition wants wants regime change through the courts. Can you explain that? Can that happen?
I think politicians are posturing, and they posture whether they're in the opposition or whether they're in the ANC. I think that what the political parties that use the court, they are doing so that there can be clarification, just as we have now had one which is dealing with questions of the behavior of Parliament. An opposition party went to court, and the courts make a decision on that matter. So yes, they have a right, political parties, companies, individuals, to use the Constitution and the laws to make sure that we are really being governed under the rule of law and not under the imagination of people in offices. So it was found that Parliament made a mistake in this particular regard. And so it doesn't mean that the courts want to take over the work of the executive or of Parliament. And I think we need to clarify that, because citizens listen more to the politicians. I'm not saying they posture all the time, but they do posture. And they have the freedom of speech. And those in Parliament have Parliament, which gives them privileges to speak. The judiciary doesn't have that. And the judiciary cannot engage in public debates around those matters. All it does its work. And if you are not happy with it, you challenge it up to the Constitutional Court. But it is a falsehood to say that the courts are trying to run the country and not the elected members. No, they have a division of labor. They call it separation of powers, and together they make the state, but they check and balance each other. That is why it is complicated.
I want to go back to something Justice Albisach said earlier, right at the top of our show, and that is the document, which is the Constitution, is a moving document. Despite the fact that it is sacrosanct, but it is a living document.
Yeah. I think what Justice Sachs was saying is important, because people think once we adopted this Constitution in 1996 and it became operational in February 1997, it should never be touched. It remains that way forever. No, because once you begin to implement it, certain things change in society, and the Constitution is supposed to guide how those new developing elements or obsolete elements ought to be removed. And that is why there's a Constitutional Review Committee, which is established under the Constitution. But not only that, there is also amendments which have been made to the Constitution since February 1997. More than 17 amendments have been effected. I think that becomes important. But there are certain provisions in the Constitution which cannot just be amended by passing an ordinary legislation, which require amendment to the Constitution, and it is a higher level which will require 2/3 of members of the National Assembly, just to ensure that we don't play with the Constitution whenever we want, like in some other countries where, presidents in office change the Constitution, the provisions relating to 2 terms, they change it to 3 terms and so on, and they create a crisis in society.
Well, Prof, quickly, we're still talking about the Bill of Rights, and a great deal has been written in you. I think you said so about the Grootboom judgment. A great deal has been said about that. And the question I want to come to is something you mentioned earlier that has to do with, if people have a gripe against the government, they mustn't go and burn buildings, burn libraries, burn cars. They must use the courts for that.
It is very important that they use the courts, but mind you, ordinary people on the street, they don't even know how to start using the courts. Secondly, even if they were organized and they want to do so, some of the cases that go to court require a lot of money to be able to hire qualified
We'll start
legal
at this point when we
yes.
come back, but let's take this call from Tulani from Johannesburg. Tulani, good afternoon and welcome to Rights and Recourse.
Afternoon. Okay, I wanted to comment on the issues on the separation of powers.
Yes.
This recent case of a public protector and the president of being alleged to have squandered money. So the President's Council and the Legislature's Council, they agreed that there were unconstitutional commissions which were commissioned by the Minister of Police, and the President, while ignoring the recommendations, of the public protector. It was unconstitutional. So now the question I'm having is the issues of accountability. If the executive has acted not conforming with our constitution, is there any accountability or any institution that can be available to hold the executive accountable? Because there is a shortcoming now in the parliament. Since the ANC is the majority, it has a majority vote. Even if when the executive has violated...
Tulani, I think we have heard your question. We have heard your question. When we come back, we'll respond to Tulani's call regarding this issue of the public protector and the separation of the issue of separation of powers. And if you'd like to join us, give us a call like Tulani. You can call us on 011 714 5497 or 5498, or tweet us at Rights and Recourse, or email your thoughts to Rights and Recourse at sabc.co.za. Stay with us.
As stories are broken around the world, SABC makes sure you do not miss out. As the stories unfold throughout the day, News at 8 updates all newsworthy stories worldwide. Globally, we are there. Locally, we leave no story untold. Make a date with News at 8 every Saturday and Sunday on SABC News, Africa's news leader.
The Department of Arts and Culture is the one that really has to push the program of, reconciliation, integrating society, and making sure that they bring the best out of every South African, particularly the young. I've always said that it lies in, making sure that the Constitution is upheld by everybody. And I've always said that it lies in no other department but the Department of Arts and Culture.
Well, Ms. Albertina Lutuli there, the daughter of Chief Albert Lutuli, talking about social cohesion and that the Department of Arts and Culture should develop that framework and work around with people so that they can understand each other. We'll come to that, and that has to do with the issues of racism. Talking about this issue Tulani raised, the doctrine, the separation of powers doctrine. Can you explain that?
The separation of powers is a doctrine which has evolved over time in society. But once it is really adopted, the Constitution does give judicial power to the courts, executive power to cabinet at the national level, and the bureaucracy and so on at the provincial level, at local government level. They are there to be able to make policy, but also to suggest laws which then go to the legislative arm of government, which is our parliament, made up of two houses, but also at the provincial level, but local government also makes certain laws. So that is how it is divided. And that's simply put the separation of powers. But as it is, we have a situation here where he mentioned the question of the Office of the Public Protector. Chapter 9 institutions, where Office of the Public Protector, the Human Rights Commission, the Auditor General, and all of those are state institutions for supporting the building of constitutional democracy in the country. In other words, we have a constitution, but which institutions are supposed to guard and ensure that we actually are faithful to the Constitution so that we build a constitutional democracy. So I think that needs to be clarified.
Professor, the other thing that we're still dealing with the Bill of Rights. Christian Howard, are you concerned that the pace of the country's transition from apartheid has stagnated?
I think that to transform a society from what it was to a new society will take time, but it needs that we work very hard and day and night to make sure that we accelerate the transformation which is taking place. We have a situation in the country where the Constitution says we want to build a non-racist society. Section 9 talks about equality. It's a protection of people against unfair discrimination and promoting equality and so on. But we are an seriously unequal society. We are seriously racist society. We are seriously sexist society. And yet all these are in the Constitution. In other words, we have a Constitution, but constitutionalism needs to be built up through concrete action, which changes the power balance in society, which empowers those who have been disempowered over centuries, so that we create a fair society.
Somebody said, Prof, about my apologies, somebody said, if we do not have these squabbles around race and around race and discrimination and all of that, life would be very dull.
Well, life will be dull, but the thing that we are engaging with this is important. But also, if you look at the Constitution, there are provisions we haven't implemented seriously. Section 25, dealing with land reform and so on, we have been moving at a snail's pace in implementing provisions within the Constitution under Section 25. We do have provisions like Section 27 dealing with issues such as food, nutrition, social security, water, and so on. And there are people who do not have any clean water at all. There are people who die from lack of food with proper nutrition and so on. So I think schools, which is another provision in the Constitution, we are not really developing a society for a new future, which will be better than the present through the education system. There's a lot that we still need to do. So yes, I think that there's a lot to be done. The fact that we have a good Bill of Rights, it is there, but it has to be translated into reality.
By deeds.
By deeds, not just
Prof,
by talk.
The other question for me is, does the Constitution adequately address race relations?
Race relations. I think that technically I can say that yes, we have within the Constitution sufficient provisions to make us deal with racism. Racism cuts across. It cuts across questions of economic, social, cultural, political rights, and so it is not just one thing. And from that point of view, yes, the Constitution under Section 1, we want to build a non-racist society or a non-racial society.
There's a reference in Section 1 of human dignity.
Yeah. Then we have human dignity. We have human rights. We have non-sexism in Section 1 as founding values. Then under Chapter 2, these are dealt with under Chapter 2 as rights. So founding values together with the rights which are in the Constitution. And then there are many laws which have been made to try and deal with each of those. But implementation, first of all, capacity to implement, even to understand what the law says and to implement them diligently without using people put in offices. All they want are positions where they can themselves benefit rather than to implement what the Constitution requires and the laws of the country require. So we need a lot to do in that regard. We have the Section 5, that 25 I talked about. It doesn't talk about things like willing buyer, willing seller of land. No, there's nothing like that in the Constitution. It is something which has been brought up by people who say government's policy of acquiring land for distribution is based on willing.
In other words, you are in full support of the Expropriation Act that's been passed recently.
I'm in support of the Expropriation Act, both under the Constitution but also international law. It's very, very important to be able to understand that our expropriation bill and what it provides for is also in line with international law. And we are also bound by international law, which is recognized in our Constitution. So people making a lot of noise about it, it is not a provision which is saying, let us take the land and you will not pay you fair compensation based on various criteria, of which the market is just one of the 5. And we haven't really interpreted it correctly through implementation. So this bill is adding very little to what there was. It clarifies it, but it is not adding anything very new.
There are a number of issues that you mentioned, especially with regard to education. There's still a big gap there. How do we fill all these gaps?
It's difficult, but I think we need to do a lot about education. First of all, the content of education. What is it that we are really putting in the curriculum that children at creche level, nursery school level, primary school level, high school level, university level, and so on are being taught? And I think that is, first of all, we need serious reflection on, because when people go to school and they come out, what do we want them to do to build society as a whole? In the economic field, scientific field, in so many areas, in health sector.
Prof, thank you very much for coming. It's a very wide discussion, the Constitution, and I'm hoping that we'll get another time to discuss just the Constitution alone. I think we have a duty to inform our people about the Constitution.
We do have
Last
a duty.
week, I forgot to recognize Justin Edwin Cameron. I therefore apologize profusely. I took a quotation from his book, Justice, A Personal Account, in which he writes, "The Constitution affords us a pathway, a healing and integration. It offers our country what the law in my lifetime has offered to me. It offers us a framework within which to repair our country, to restore, redress, and reconcile. It is up to us to claim the opportunities it offers. For the Constitution exists not only for high dreams and the good times, it is there also for the moments of dismay and sobriety." This has been Rights and Recourse. This program is repeated at 5 on Monday morning. From all of us here in the studio, do find us on Twitter and also on YouTube. Goodbye.